Hello again, everybody. This is kind of an impromptu video. I didn't really plan to do this, and I didn't expect to get this heavy this quick. I was going to try to take baby steps, but I talked to my aunt last night, and we were talking about some legal matters, and I thought I'd throw a little video together to help her know what's going on a little bit. So this is going to be two parts. I started this and it got to be 20 some slides, 30 slides, and I saw it was going to be too much for one video. So just bear with me. This is, like I say, this is impromptu, and I have had only maybe an hour to put the slides together and have not really gone over the information as well as I would have liked to. But we're going to give this a try. And I'm calling this one How to Survive a Legal Attack. Now I've got to tell you, this is not legal advice. It is the way I would do it. That is my opinion. Only a licensed attorney can give legal advice. This is for entertainment and educational purposes only. If you need counsel, please seek a legal professional and then be advised. Okay. There are four main steps in a legal action. The first one are the pleadings. One party files a complaint alleging another party committed a wrongdoing. The other party then submits paperwork answering the complaint and detailing their version of the events, that is, the facts, and only the facts. Now you got to keep emotion out of this when you're doing legal pleadings, and sometimes that can be very hard to do. So anyway, the lawsuit must be filed with the appropriate court. You got to make sure you're in the right jurisdiction. The initial pleading is called a cause of action. Now this pretty much is the same whether it's a civil, criminal, whatever, because eventually you'll find out that everything is civil. Even the criminal is civil. The elements of the cause. 1. On such and such date, so-and-so. 2. So-and-so did this to me. 3. Causing me this harm. And 4. This is the relief I am seeking. Or the remedy. Remedy, relief, they both work. So to summarize, the initial pleadings phase is in two parts. The harm parties, or the plaintiff's filing of a cause of action, detailing what happened, the harm it caused, and the relief sought for the injury. And the second part is the one named in the action as causing the injury. The defendant answers the plaintiff's claim. Then the fun begins. Phase 2 is discovery. After the pleadings are filed, then each party enters into discovery. Discovery is a process where both parties start to obtain information that will strengthen their side of the case. This information is called evidence. So during the discovery phase is when the attorneys or the person bringing the cause or answering the cause will collect everything that they can do to make it seem more favorable to themselves, or to find impeachment evidence, to prove the other person is lying, what have you. It's a very important stage. Then if you can't resolve it by this point in time, and really the best thing to do anytime you run across a situation, try to resolve it before you get to this point, before you ever get it to the courts. So the next phase is the trial. If a case has not been resolved yet, then after discovery the case will move to trial. Trial may be in front of a jury or judge only, or may be in front of a selected jury. The one or ones who decide the outcome, whether the judge or jury, is called the trier of fact. Sherry, would you deal with Bailey the super dog? We have somebody that's wanting to go outside. Please excuse us for a moment. The trial process. Both sides submit a brief to the judge that outlines their arguments that will be presented and the evidence they will use. Each side will then present an opening statement, again outlining their case's points. The case will then begin with the plaintiff first. Each side may present their evidence and witnesses and conduct cross-examinations. Once completed, each side will make their closing statement. The trier of fact will then determine whether the evidence presented by the plaintiff prevails or the rebuttal of the evidence by the defendant prevails. And that's it in the nutshell. It seems a little simple, but it really is a simple process. And in a perfect world, the truth prevails. This should be the foundation of justice, determining the truth of the matter asserted. But rarely does it turn out like this. We live in a litigious society, and everybody wants to sue everybody for anything. That's just wrong. Everything about that's wrong. And I should take a moment here to say the things that I'm sharing with you, I would hope that nobody listening to this would take that and try to use it to take advantage of anybody else, because that's really, really bad. We'll take a look at how bad that is here in a few minutes. Usually, he who can afford the best liar wins. No, I didn't mean lawyer, I meant liar. Licensed bar attorneys are licensed to lie. In fact, the entirety of the legal system is a lie. If I offend any attorney out there by that statement, sue me. I can prove this statement beyond all doubt. Now, if you look up attorney in Corpus Juris Secundum, which is a legal encyclopedia, you'll find that their first duty is to the bar, which is the British Accreditation Registry, which all attorneys are members of. They've completely hijacked our legal system and control everything. It's not the way it was supposed to be when this country was set up. But that only lasted less than 10 years before they had wiggled their way in and started messing things up really bad. So like I said, if I offend any attorney out there by that statement, sue me. I can prove the statement beyond all doubt. And reasonable doubt is garbage. If there's doubt, there's doubt. And there should not be a conviction or an award of a settlement if there's any doubt. But it serves the attorneys to have the reasonable doubt, lost the word, standard. 4. Appeal. If either side does not agree with the result of the case, they can appeal to an appellate court. The appellate court will review the case from the record of the lawsuit and determine if any errors were made that would affirm the previous decision, merit a reversal of the decision, or order a new trial to be performed. The appellate court is limited to the record of what took place in the proceeding. The appeal is not an opportunity to retry a case, so it's not like you get an extra chance if you screw up the first time. Just take it to the appellate court and get to put on the evidence you missed, or get to do this or get to do that. No, any errors have to be preserved, and that's generally done through the objections. That's why you hear objection sustained, objection overruled, and they really aren't giving a lot of explanation to what's going on with the objection process. But what that is preserving issues for appeal. And like I said, you don't get a second shot at this. They have to stay to what was recorded in the court, whether it's a recording or whether there's a transcript or what have you. That's the entirety of what the appellate court can look at. Okay, this is the end of part 1, the process. Now, what I would do to survive the attack. Points to remember. Number 1, American jurisprudence is adversarial in nature. Make no mistake, you are at war. Your opponent wants to do you real harm. 2, expect the unexpected and take nothing for granted. If your adversary or her agent comes to you, it is most likely to trick you into condemning yourself. Truth is usually not the issue unless you have truly trespassed against your neighbor or his or her property. If that's the case, if you're at fault, pay up. It's the right thing to do. Do not compromise your faith. This is probably the most important part of this. Messiah said in Matthew 16:26, "For what is a man profited if he shall gain the whole world and lose his own soul? Or what shall a man give in exchange for his soul?" In Matthew 5:25, Messiah said, agree with thine adversary quickly, whilst thou art in the way with him, lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison. And right there, Messiah is showing us that he has knowledge of this process, this administrative process that I'm going to be talking about, because this is exactly the way it should work at all times. You should try to settle the matter between you and the person that you're at odds with. Matthew 5:23 says, this is the same discourse. Messiah says, therefore, if thou bring thy gift to the altar, and there rememberest that thy brother hath aught against thee, leave there thy gift before the altar, and go thy way. First be reconciled to thy brother, and then come and offer thy gift. Now I added the emphasis in there, that those words that are highlighted and are italicized, because he's not saying if you take your gift to the altar and there remember your brother's done you some wrong, you go get the guy, make it right. That's not what he's saying. He's saying you should look at your own actions. Concentrate on yourself rather than concentrating on what your brother's doing. So, if you remember that your brother has something against you, is the point he's making here. And that's a very, very crucial point, especially for the Netzarim, for those of us who are trying to walk in Torah and trying to live life the right way. We don't want to be the cause of problems. We want to be at peace with all men as much as it's possible with us. But that being said, the best defense is a good offense. And that's really the only defense. Briefly, I'm going to mention something called parse syntax. And that has to do with the way words are constructed. The word defense, for example, DE means no. So what that word really means is no fence or no protection. If you're in a defensive posture, you have no protection. And they tell you, but this is one of their words of art. When you go in as the accused, they immediately turn you into the defendant. And when you're the defendant, you don't know it, but they've shifted the burden of persuasion. They've put you in the position where you have to prove your innocence rather than them having to prove your guilt. But they don't tell you any of this. So, file a counterclaim to go on the attack. In a combat situation, if one side's pinned down, they're at a disadvantage and usually just trying to survive until rescued. In a legal action, no one's going to ride in on a white horse and save you. You have to save yourself. The cavalry is not coming to save you. I can't stress this enough. You must save yourself. But it is not hopeless. You can prevail. The following assumes you've done your best to resolve the situation and the other party to the action is unreasonable and wants to move forward. At that point, it is truly kill or be killed. Go for the jugular, take no prisoners. The best way to do this is a counterclaim and win before it ever goes to court. Note, there are no judicial courts left in the United States. All so-called courts of law are under the legislative branch of the government. It is beyond the purview of this video to prove this at this time, but I will prove my claim in a subsequent video. The rabbit hole truly runs deep, and everybody needs to understand how they've hijacked our legal system and how we are actually, the legal system is just an extension of the beast system. Remember, there's father's system, there's the beast system. You're either in one or you're in the other. And the courts are in the purview of the beast system. All courts are under the legislative branch of government and are therefore administrative tribunals. But they always claim to be courts of record. Always remember, they can lie to you. And in 2012, Obama repealed an act, or he might have only modified the act. It's called the Smith-Mundt Act. And I will be writing something about this later, but I believe it was 1948. It was put in place so that the American government could not propagandize the people. In 2012, Obama said, yeah, it's okay to use propaganda on the citizens. So you need to remember that they can always lie to you. But if you lie, it's perjury, and perjury is a felony. In fact, sometimes when they have a weak case, they might try to get you to perjure yourself, or to get you to get into contempt of court, which, depending on the jurisdiction and whatever state laws you're under, that can be a felony also. So your remedy lies in the administrative process. In part 2, I will explain how I win before I ever go to court. This is the only way to win, except not to play. But one seldom has that option. You're dealing with somebody who's unreasonable, and you really don't have any choice. If you're a peace-loving person, you're really trying to walk in the footsteps of Yahusha, you're trying to obey Torah, you're not going to end up in court by your doing. It's somebody else coming at you. Now, Romans 13 has been abused, and I'm not going to go into that right now. We might address that in a future video. I'm sure we probably will. But I'm going to draw your attention to the night of Yahusha's arrest. When Judas came and kissed him on the cheek, Peter took out a sword and cut off the guy's ear. Okay? Now, also, you remember the money changers in the temple. Yahusha went into the temple and turned over the tables. They weren't wimped. And when Yahusha was arrested, Peter was strapped. He had a sword. So, take a look at the situation there. I don't believe that we're supposed to roll over and play dead all the time. Now, sometimes that's the more prudent way, but not always. Would you let Bailey in, please? Sometimes you gotta fight, and if you have to fight, you have to fight to win. Remember, this is not legal advice, but a testimony of what I have done to avoid litigation. I've never had to file a suit, but I've used the administrative process to nip in the bud aggressive legal attacks, and it works. I call it the porcupine method. You just make it to where they don't want to touch you. It's too dangerous for them to touch you. And a lot of times, a proper administrative remedy can make everything go away, or it can put you, if you've been caused a harm that you feel that you need to be compensated for, it can put you in the situation where you can get that compensation. We're going to go into it further in the next video, but the administrative remedy is where you put them in dishonor through an affidavit of truth that they can't answer. Then when they default on that, you have a perfected claim. Then when you go into court, the judge has absolutely no discretion. He has to rule in your favor. There's a maxim of law that an unrebutted affidavit stands as the truth in commerce. And everything now, since they've changed the rules, changed the system beyond what the founding fathers meant for this country to be under, everything now is commerce. Everything is about money. So that maxim that the undisputed affidavit stands as the truth means you've won before you ever go to court. But I'm going to lay that out and put it in some slides so that you can refer back to it, and hopefully it'll help you to start wrapping your mind around this process a little bit. If you choose to try this remedy, get a licensed attorney and make him work for you. Now, there are some pitfalls with an attorney. When you hire an attorney, you are considered an imbecile, an idiot, and a ward of the court. And the state has to take care of you. And that's all another one of their lies, because taking care of you means screwing you over. And there again, as we get into this more and more, I will explain this all in detail. So anyway, look for part 2. I'll call it Using Administrative Remedy to Prevail Before Court. And that's really the best way to do it. If you're already involved in an action, it's not too late. You all know by now that I'm fighting a couple of misdemeanors. I've done the unthinkable. As of, what's the date today? The 9th? Yes, as of today, it's been 1 year exactly that I have been in court on the first one. and I've not filed a plea yet. I've not entered the action. I am in a position to where I'm going to have to take my own advice, and I'm really a little reluctant to do that because I've taken on 3 judges, at least 2 state's attorneys, and 2 branches of the sheriff's department. So it's kind of painting a target on me. If I could just move out of the state, you know, I'd just give them what for and can get out of the state, but I can't. That's not doable for me. So I'm trying to figure out how far I want to do this and how exactly I want to take this. But I have been spending the last year collecting evidence against them. And all I have to do now is to file an affidavit of truth. What I want to put in that affidavit, I don't know yet. There's a couple ways to attack it, and I'm leaning more towards the easier, softer way. I don't really want to poke the bear in the eye too many times. It's only a matter of time till you get bit when you do that. Even if I'm in the right, and I am in the right. I'm in Illinois, and on the second arrest, they came into Wisconsin when somebody tried to run over my dog and myself. I called for the Wisconsin police. The Illinois police came into Wisconsin, and then they arrested me because they thought I was being too loud and unruly. I was mad. I'll tell you, I was mad. Somebody just tried to kill me. And it didn't go real well for the guy. It ended up in a little bit of a fist fight, and I got the better part of him, but I was pumped up. When they got there, I was trying to get them to get the Rock County, Wisconsin police. They wouldn't do it, so I ended up going to jail in Illinois. However, I can prove that they walked outside their jurisdiction and did something that they were not qualified to do nor allowed to do by law. However, doing that might not be the wisest thing in the world. So you do have to use, discretion when you do these things, and you can't be led around by your emotions. You got to think it through. And I go to court again on the 28th of this month. By local rules, I have to file any paperwork 2 days ahead of time, and I won't file my paperwork until maybe 3 or 4 days ahead of time. I'm not going to give them a lot of time to prepare for what I'm going to bring at them. But I think with Yahuwah's help and the fact that I'm in the right on this, that I will prevail. But, it's a danger. It's a real danger. Anytime you enter into this system, it is a danger.
Especially in Illinois.
Yeah, Illinois is bad. So, anyway, thanks for listening. I hope this helps everybody. Like I say, this was impromptu. I don't have any notes to work from, and I just threw these slides together real quick, so forgive me if it's not as professional as I'd like for it to be. When I started this, my goal was to make each video more professional than the video before it. But, with the help of Bailey the Superdog and my lack of preparation, I might not have achieved my goal this time around. But thank you for listening to me, and thank all of you who have subscribed to my channel, and thank you for your comments. They're much appreciated. I'm ready to start taking off with this thing a little bit, so I would ask you to subscribe and to share. Again, thank you very much, and may Yahuwah bless you all.